Thank you, Mr. Chairman. Thank you for your testimony. I want to pick up on some of the questions that Senator Brown asked regarding materiality. You indicated that you thought that the triggering event for disclosure would be whether there'd been a material change in the circumstances of a company, right?
Yeah, that's generally
right. And I understand you don't want to get into the Equifax situation, but you would agree that, not talking about any company, that if in fact there was a material change, it would be wrong for executives of that company to then knowingly trade stock before they'd made any disclosure, right?
Yes, sir.
Okay. So I want to get to what materiality means, because I don't believe the SEC has any definition, at least in the context of a cybersecurity breach. Is that right?
I think the general definition of materiality does apply to the cyber context.
Right. No, I don't mean that the concept doesn't apply, but there's no standard or definition of how to apply the concept of materiality to a cyber breach. So, for example, the SEC doesn't say if a cyber breach would result in the disclosure of, X amount of information about customers, and that could lead to a significant change in the value of a company. The SEC doesn't itself have that kind.
That's correct. There's no prescriptive disclosure of this many people for this long. Right. We don't have that type of.
So it's kind of you know it when you see it. Is that the idea?
That's fair.
But does the SEC bring these kind of materiality cases for failure or violation of 8K disclosure?
We do.
Okay. Let me ask you, if you agree that it is wrong for people to knowingly trade on information that's material but has not been disclosed, would you agree that once a company has decided something is material, that their executives should not be trading that stock between the time they decide it's material and the time they actually file the disclosure to the public, which is now a 4-day period potentially?
I'm going to be very here. I think what you're asking is a control issue. Should there be a control in place to ensure that when a decision has been made at a company that there's been a material event and there's going to be a disclosure, that the company has in place a control to prevent.
Yes, that is exactly what I'm suggesting.
Yeah. No,
wouldn't that make sense?
And I think it's a very good question, and a fair question.
Well,
whether that's an area over that goes into insider trading, or whether it goes into a control failure, is something that we need to.
I understand. It seems to me there should be a presumption that once a company has decided there's been a material change, and before they disclose that to the public, there should be just a rule that executives don't trade that stock. Doesn't that make sense in terms of protecting the markets?
I do not want to comment on any specific company.
No, I understand that. I'm not asking about a particular company.
Most companies have insider trading policies. Having a thoughtful insider trading policy with controls of the type you're suggesting is an important part of good corporate hygiene.
Well, let me look. I'm working with Congresswoman Maloney on the House side has a proposal. We're working on it with her. But there's a whole question about when you determine materiality, right? We're talking about that. But it seems like a no-brainer that once a company has determined that there's been a material change, and before they've notified the public, which they have 4 days to do, you would require them not to sell stock. Why isn't that just obvious?
I like the concept. When I was in the private sector, I put the concept into insider trading policies that, for example, a general counsel would be somebody that a set of executives had to clear all trades with. Yeah. Those are types of things. Those are types of.
Well, let me just say, so there was a study done back in September 2015 by Alma Cohen at Harvard Law School, Robert Jackson at Columbia Law School, Joshua Mitz, and others have done studies that showed what they call the 8K trading gap, which is that executives have made money during this 4-day period or whatever time elapses between a decision that some material change has been made and disclosure. Do you agree that it's wrong for executives to be making money during that period based on information they have about materiality.
Absolutely.
Right. So
Absolutely.
shouldn't there be a general rule that once the corporation has made a decision that something is material, that they not be allowed, their executives not be allowed to trade during that period?
I like the concept.
Okay.
I've
We'll look forward to
incorporated the
working
concept.
with you on this
We can work
because
on it.
we
We can
can adopt
definitely
this.
work on it.
We're working on a bill. Thank you.